been working very much on the front line. So too, in a slightly different sense, as Mona Sadek from the ICRC, the deputy head of the ICRC's mission to this country, to the United Kingdom, in terms of her engagement and organisations' engagement with political, military and non-government organisations relevant to everything we're talking about here today.
Thank you. Perhaps just to start by echoing Jahangir's appreciation and welcoming to this excellent and very substantive report by HPG. I think it's extremely timely. Measures criminalising support to terrorism aren't new, as mentioned earlier, but they have widened in scope and in impact since 9/11. And despite this continuing lack of agreement around a definition of terrorism itself, as was mentioned, lists of prescribed terrorist organisations have been drawn up by the UN, by the EU, by regional bodies and by states domestically. By excluding contacts with parties who de facto control territories or may represent a security threat if no dialogue has been established with them earlier, the ability of humanitarian organisations to access populations in need is severely curtailed. So the immediate risk for humanitarian organisations comes from this criminalisation of any form of support or services or assistance to or otherwise association with non-state armed groups indexed as terrorist organisations, either domestically or internationally. Now, armed groups designated as terrorist organisations include many of the entities with which the ICRC is currently engaged in an ongoing active humanitarian dialogue, as well as other humanitarian actors. Groups as diverse as Hamas or the FARC to Tahrir al-Taliban and Shabab, or formerly the LTTE. Anti-terrorist international and domestic legislation can be said to operate at different levels when it comes to the impact on humanitarian action. In terms of direct implication to humanitarian organisations themselves, as we've heard, these measures have so far translated mainly into funding difficulties. But there is also the potential criminal liability of humanitarian workers. And on a more generic level, anti-terrorist measures may also have an impact on international humanitarian law and on neutral, independent humanitarian action. With regards firstly to the possible direct effect on humanitarian organisation, and of course to start here by saying that states have clearly many legitimate concerns with respect to national security and have both a right and a duty to prevent and suppress acts of terrorism. The concerns that arise in relation to humanitarian work is when those measures have an impact on the funding of neutral, impartial humanitarian bodies. Now, others have spoken at length about this, so I won't dwell on it much further. Beyond saying that in the ICRC's case specifically, major donors have so far made significant efforts to accommodate the ICRC's way of working when it comes to funding, and for this, of course, we're extremely grateful. At another level, and beyond funding restrictions as such, the concern is that activities which are exclusively humanitarian and impartial in nature may still fall within the definition of what constitutes support or services to terrorism, raising at least the potential for criminal prosecution of humanitarian organisations and their staff members. Now, the exact content and scope of the criminal offences associated with supporting or assisting these entities vary from one state to another, some states circumscribing these criminal offences narrowly to exclude humanitarian action, but generally speaking, this tends to be the exception, unfortunately, rather than the norm. In terms of the ICRC's work, our concern is that the prohibition in criminal legislation of unqualified acts of material support, services, assistance to, or association with terrorist organisations could, for example, result in the criminalisation of many core activities of the ICRC aimed at meeting the needs of victims of armed conflict and other situations of violence. These could include visits and material assistance to people suspected or charged with terrorist offences, visits to detainees who are being held by entities themselves prescribed as terrorist organisations, first aid training, war surgery seminars, or IHL dissemination to members of armed opposition groups, or distribution of food to IDP camps where some of the beneficiaries may be on a prescribed list. It must be said here that to date, the ICRC has generally not encountered practical difficulties resulting from the changing language of instruments of national and international law with respect to its potential beneficiaries, although we are regularly approached on this point by donors and by states. We hope this, of course, will remain the case and extend our interest and concern to the access and manoeuvrability of other actors. Regarding international humanitarian law, it should be recalled here that Common Article 3 to the 4 Geneva Conventions of 1949, which is a bedrock provision of IHL, provides that, quote, an impartial humanitarian body, such as the International Committee of the Red Cross, may offer its services to the parties of a conflict. So humanitarian engagement of non-state armed groups that are a party to a non-international armed conflict to which this article refers is thus a task which states have explicitly granted to the ICRC and to other impartial humanitarian organizations. I've already mentioned some of the types of activities which the ICRC traditionally engages in times of conflict. Now, the broad language or broad interpretation of language in criminal legislation prohibiting services or support to terrorism could prove to be a serious impediment in the carrying out of these activities and therefore the fulfilling of the ICRC's mandate. There are other ways in which anti-terrorism measures could run counter to IHL. Among them, the difficulty to apply IHL prescriptions aimed at fostering national reconciliation after a non-international armed conflict. For instance, it would likely be very difficult for a government that is party to a non-international armed conflict to sit down and negotiate a ceasefire or a peace agreement with an enemy armed group if that group has been included on an index terrorist list and therefore subject to the absolutist prohibitions of the international counter-terrorist regime. Moreover, the treaty-based and customary IHL requirement that governmental authorities in non-international armed conflicts should endeavour to grant the broadest possible amnesty to people who were involved in fighting that conflict or people who were detained in relation to that conflict will also be very difficult to apply in practice where non-state armed groups are designated as terrorist. And the exception here is, of course, people suspected of war crimes. Simply put, this designation is likely to inhibit efforts to bring an end to armed conflicts through dialogue with these same armed groups. This being said, it must of course be recognized that the label of terrorist is one known to have been dropped or changed when political parameters shift and when negotiation becomes the favored way ahead. Nonetheless, the point stands that possibly such negotiations could have evolved more constructively had they started earlier. Another important concern for IHL is the impact on detainees suspected of terrorism and the fact that some states have in their counter-terrorism laws imposed restrictions on certain judicial guarantees to this particular category of detainee. The ICRC observes this firsthand in the context of its visits to detainees suspected of terrorist offences. Negative effects on judicial guarantees include extended periods of investigative detention, restriction on access to lawyers, secret evidence to which the accused has little or no access, and in some cases the potential admissibility at trial of evidence extracted under ill treatment. Conversely, the UN in its global counter-terrorism strategy and EU policy organs have emphasized the need for states to ensure that their counter-terrorism measures comply with their obligations under international law, including IHL and international human rights law. With regards to neutral, independent humanitarian action, potential criminalization of humanitarian action may also be said to preclude respect for the fundamental principles of the Red Cross and Red Crescent movement, which bind the ICRC and other components of the movement. And on a more generic level, the basic approach to neutral, independent humanitarian action. The principle of neutrality means that the movement may not take sides in hostilities or engage at any time in controversies of a political, racial, religious, or ideological nature. Now, the ICRC or the movement couldn't abide or be seen to be abiding by this principle if they were directed, as a result of anti-terrorist legislation, to work in favour of a population on one side of a political divide in a situation of conflict or other situation of violence. In many instances, it would force an organisation like ours to work on territories controlled exclusively by a government which was recognised by other states internationally. ICRC visits to places of detention worldwide, either required or allowed for in the universally ratified Geneva Conventions, demonstrate an inherent tension between, on the one hand, the prohibition of services or support language in counter-terrorism measures, and on the other, the actual playing out of the principle of neutrality on the field. The ICRC endeavours to visit all people detained in relation to an armed conflict, regardless of the side to which they belong, in order to ensure that they are humanely treated and that basic rights are being respected. This role, which is widely supported by states, is at the crux of the organisation's work in detention, and yet could possibly be called into question because of the lack of exemptions for humanitarian activities in anti-terrorism measures. Moreover, visits to people detained by non-state entities are often crucial because it's these people who are frequently the most vulnerable in contexts of conflict. In our view, persuading and helping a specific party, regardless of whether it's been indexed terrorist or not, to respect its own humanitarian obligations does not constitute a support as understood by the anti-terror clauses and should not be called into question. In terms of the principle of impartiality, the ICRC and other components of the movement may not discriminate based on nationality, race, class or political opinions and are bound to, quote, relieve the suffering of individuals being guided solely by their needs and give priority to the most urgent cases of distress. In other words, the limiting measures we have been discussing may lead to a de facto distinction between good and bad victims, depriving people in need of necessary assistance because of their political affiliation or because they're under the authority and being controlled by a designated terrorist organization. The ability of the ICRC and of National Red Cross and Red Crescent societies to, for example, provide medical assistance to all victims of armed conflict and other situations of violence, in keeping with this principle of impartiality, could be hindered by the broad language of anti-terrorist legislation. A strict reading could imply that medical services to people rendered hors de combat by wounds or by sickness, as well as to other people under the control of a non-state party designated terrorist, could be prohibited because of being seen as being support or assistance or services to terrorism. This is a result which would call into question the very idea behind the creation of the ICRC and subsequently the Red Cross and Red Crescent societies some 150 years ago. Now, while the ICRC has not been challenged on the substance of its humanitarian work so far, current anti-terrorist legislation has increased dramatically NGOs' liability, as we've heard. Technically speaking, a humanitarian organization could be brought to justice for having operated in Somalia or in Afghanistan in areas under the effective control of opposition groups labeled as terrorists because of the very broad definition of material support. This is not acceptable, although organizations entertaining a dialogue with such non-state armed actors should take the necessary measures, of course, to prevent, as far as possible, abuses of aid. In conclusion, to summarize, there's a need for a greater awareness by states of the necessity to harmonize their policies and legal obligations in the humanitarian and anti-terrorism realms so that the provision of legitimate and necessary humanitarian aid is not hindered. Specifically, legislation creating criminal offences of material support, services, assistance to or association with people or entities involved in terrorism should exclude from the ambit of such offences activities which are exclusively humanitarian and impartial in character and conducted without adverse distinction. And lastly, in respect to the ICRC in particular, it should be recognised that humanitarian engagement of non-state armed groups is a task foreseen and expected of the ICRC under Common Article 3 to the Geneva Conventions, which allows the ICRC to offer its services to all the parties in a non-international armed conflict. Criminalisation of humanitarian action would thus run counter to the letter and the spirit of the Geneva Conventions. In other words, the broad language prohibiting services or support to terrorism could make it impossible for the ICRC to fulfill its conventional and statutory mandate in contexts where the armed groups party to a non-international armed conflict have been designated terrorist organisations.
Mona, thank you very much indeed, and a few organisations more steeped in all this than yours, of course.